could find itself on trial here because they're blowing 45 too damn hard. The third impeachment in United States history has launched two trials, one of 45 and the other of the Senate itself. If the Senate refuses to convict 45, either because it refuses to hold a full and fair trial or because it simply disregards the grave nature of his abuse, its action will severely undermine American constitutional government. The first question is whether Senate Republicans will hear all the relevant evidence or merely orchestrate a cover-up. There are many fact witnesses who have not yet testified, including the squatter himself, and floods of relevant new documents emerge virtually every day. To actually try this case, the Senate must hear those witnesses and consider those documents. To refuse to do so is to deny the implicit constitutional mandate requiring an honest and good faith proceeding in the Senate to establish truth. Revealingly, some Republicans have proclaimed that they will ignore that mandate. Senate Majority Leader Mitch McConnell and Senate Judiciary Committee Lindsey Dumbass Graham have announced that they will not act as impartial jurors, while they and other Republicans have conspired with 45 and his legal team to develop a false defensive strategy. Spotlighting their clearly brazen constitutional infidelity, those same Republicans were willing to take an oath swearing that they would be impartial in the Senate trial. The numerous contrary statements and collaborative efforts they made with 45, however, have disqualified them as impartial jurors in the Senate trial and condemned them before everyone who believes that oaths are not merely binding but sacred. Those Republicans feel compelled to engage in such transgressions for an imperative political reason. They recognize that they must exclude those witnesses and documents because they would further support the case against 45. Indeed, their determination to exclude that very evidence testifies to their recognition that it is considered fairly. The additional information would almost certainly require that they convict 45, which that's one of the reasons why they don't want to bounce. That's the reason why they're bouncing up and down the dick too damn hard. The resolve by Republicans to exclude those witnesses and documents show that they understand their legal significance, as most Democrats do. Both groups are convinced that the witness and documents would confirm that 45 is guilty, which he is. Both their positions exemplify the unbearable conflict that is the hallmark of every trial. One side seeks to introduce evidence because it helps, while the other strives to exclude it. The opposition by Republicans to new witnesses and documents fits that classic pattern and corroborates the conclusion that Republicans themselves understand the damning nature of that evidence to 45. Some of the purported defenses that Republicans raise demonstrate the logically untenable position they take. They contend quite falsely that evidence against 45 is only hearsay, which it's not. If they truly believed that, they would, in basic fairness, have no choice but to allow the introduction of non-hearsay evidence and would be obligated to secure the testimony of those critical witnesses, which include John Bolton, Mick Mulvaney, Rudy Dumbass Giuliani, Rick Perry, and others who could provide the non-hearsay evidence. Republicans cannot legitimately justify refusal to convict on the ground that the prosecution has only hearsay evidence when they refuse to allow the prosecution to present evidence that does not qualify as hearsay. Republicans contend, again quite falsely, that 45 cannot be convicted because he broke no law. Technically, he can be convicted because he broke a fucking law. Relying on that contention, Republicans cannot properly refuse to allow into the record the finding of the Government Accountability Office that the squatter did in fact break the law when he ordered appropriated funds for Ukraine to be withheld. They cannot justify refusal to convict because there is no evidence that 45 broke the law when they refuse to allow in evidence that he actually did just that. The second question is whether, in spite of all the conclusive evidence, Republicans will retreat to the claim that the actions by 45 do not rise to the level of impeachable offenses. Yes, it does. If Republicans do so, they will have endorsed the dangerous principle that a squatter may use his power and override Congress and its mandated proportions in order to defame a political rival and gain an unfair personal advantage in the next election. That abuse of power is precisely what the founding fathers feared most, in that a squatter might exploit his own office by conspiring with foreign forces to sacrifice the interest of the nation in order to pursue his own. The threat of foreign corruption, Alexander Hamilton warned, meant that those of great preeminence and power may find compensations for betraying their trust. Accepting the principle that abuses by 45 are not impeachable offenses would raise a foundational principle of our constitutional system. If Senate Republicans refuse to convict 45 by preventing a fair trial or denying that his actions are impeachable, their verdict will not acquit him of anything. It will, however, convict Senate Republicans of betraying their own constitutional duty. Future squatters will know they can abuse their power without limit as long as they can entice or intimidate a third of the Senate to join them. The rule of law in this nation will have collapsed and little will remain about the selfish and destructive drive for a raw party anywhere.